provided on Channel 2 in English.
네, 즐거운 점심시간 되셨습니까? 이제
I hope
2022
you
국제 특허법원
enjoyed
콘퍼런스의
lunch.
마지막
Now
코너입니다.
we will move on
오늘
to
오전에
the
살펴본 손해액 산정에 관한
last
쟁점을
session
바탕으로
of the
엮어본 가상의
2022
사례를 통한 모의중재를
IIPCC.
시작하겠습니다.
We will
사안의
begin
개요
with the
설명,
moot arbitration.
중재인 소개, 대리인 소개,
We will
구두변론,
proceed as
중재인
the
질의, 대리인
index on the
최후 변론,
slide
중재
outline
판정
of the
순으로
case
진행하겠습니다.
introduction of arbitrators and
이번
attorneys oral
모의중재
proceedings,
준비팀이
questions
가상의
from
사안을
arbitrators,
구성해
final
보았습니다.
oral
손해액
proceedings and
산정에
arbitral
관한
award. The
많은
preparation
쟁점을
team put
현실감 있게
together
넣어서
a
구체적인
hypothetical
결론에
case
이르는
that
과정을
encompasses
비교법적으로
various
살펴보고자
issues
하는
regarding
취지입니다.
damages
사안의
calculation and leading
개요를
to a
말씀드리겠습니다.
detailed conclusion. The purpose is
원고는
to
드럼 세탁기
comparatively review
구동부에
such
관한 아래
process.
특허권을 소유한
Here is the
회사로
overview.
드럼
The
세탁기를
plaintiff
제조
is a company
판매하는
that owns
회사입니다.
the patent below on
피고는
the driving unit of the
드러머라는
drum type
제품명으로
washing
모터의
machine,
구동력이
which is the
드럼에
product they make
직접
and sell. The
전달되도록
defendant
하는 드럼
produces a product
세탁기를
named
제조
drummer,
판매하는
wherein the driving
회사입니다.
force from the motor
피고는
is directly
전자업계에서
delivered to
원고보다
the
훨씬
drum.
큰 규모의
The
매출을 기록하는 회사이고
defendant records higher
원고는
sales
특허로
than the
창립된
plaintiff, and the
신생회사이나
plaintiff is a
점점
relative
생산 능력을
newcomer that
늘려왔습니다.
started its business with the patent but has been growing its scale of business.
네, 죄송합니다. 드럼 세탁기는 그림에서 보듯이
The drum type
10개의
washing
부분으로
machine
구성되어 있습니다.
comprises of the following
이
10
사건에서
elements on the
문제되는
slide.
부분은
The component
3번입니다.
at issue
드럼을
is number
회전시키기
3,
위한
the driving unit
구동력을
generating
발생시키는
driving force
구동부입니다.
to rotate the drum.
원고의 특허 발명을 살펴보겠습니다.
The plaintiff's
굉장히 첨부하게
patent
복잡하게 되어 있는데
has many complex
원고는
claims.
드럼 세탁기 구동부에 관한 특허로 2018년
With the
1월 6일 출원해서
patent on the driving
2019년 1월
unit, it was
31일 특허
filed
등록을
on
받았습니다.
2018 January 6th and
중재전
registered on
소송
January
단계에서는
31st of
그 세탁기의
2019. In
구동부
the litigation
지지구조가
proceedings
쟁점이
before the
되었습니다.
arbitration, the structure of the supporter was at issue.
다음은 피고 제품입니다.
This is
슬라이드
the
그림과
defendant's product
같습니다.
on the slide. It is characterized,
터브 후보역부
as you can
측으로
see,
돌출되는 제1돌출부
the first
P1,
protrusion
스테이터 측으로
P1 protruding to
돌출되는
the tub's rear
제2돌출부
wall,
P2가
and the second
형성됨을
protrusion
특징으로 합니다.
P2
피고
is
제품은
protruding to the
이
stator.
특허 외에도 이 부분에 관한 특허 외에도
And
피고가 권리를
besides
가지고
the
있는
patent,
19개의 특허 기술이 결합되어
the
있습니다.
product is combined
피고
with
제품은
19
오른쪽
patented
등록
technologies
디자인권을
owned by
적용한
the
제품입니다.
defendant.
디자인
Also, the
형상은
registered
오른쪽과 같습니다. 이
design on the
디자인도
right is applied to the
소비자들의
product,
구매에
which is a
영향을
huge
미치고 있습니다.
driver of customer demand.
사실관계를 날짜별로 정리해 보았습니다.
Now, this is the timeline of what happened. The defendant has been constantly monitoring the patented product of the plaintiff. Plaintiff filed for the patent on 2018, had it registered on January 31st of 2019, and manufactured and sold the product with the patented technology from June 2018. The defendant succeeded the right to its employee's invention, which was believed to be a new idea compared to the plaintiff's patent, filed and registered the patent on June 30th, 2019, and began selling its products from July 10, 2019. The plaintiff sent a notice to the defendant to stop producing and selling the product on May 2nd, 2020, but even after receiving the notice, the defendant concluded that its product does not infringe the plaintiff's patent and continued business. The plaintiff filed suit against the defendant claiming damages for patent infringement. The defendant increased its production of sales of its product. But during the year 2021, there was a disruption in the supply of the semiconductor that was necessary for the driving unit, which halted or undermined production and sales. The plaintiff sued the defendant, asserting a violation of the Patent Act, and the investigation agency applied for a summary order imposing a fine of 4 million won. The court rendered the summary judgment for the fine, but the defendant requested trial on the summary order, and the court is now hearing the case in a criminal trial regarding the alleged Patent Act violation. The defendant denied during the proceedings that the production and sales of its product infringes the plaintiff's patent. But during the parallel arbitration, they admitted that its product fell under the scope of the plaintiff's patent and ceased production from May 1st, 2022. The plaintiff's production capacity, sales quantity, defendant's sales quantity, and total market sales is shown from 2019 to 2022. The plaintiff's sales and production is increasing. Defendant's sales and production has been increasing,
이익액입니다.
but
단위당 판매 가격,
after it's
단위당
suspended,
변동비,
it
단위당
was decreased from
판매
2021.
그리고 아래
And this
부분은
is the
피고
profit per
제품의
unit
단위당 판매
of the plaintiff's
가격입니다.
product, unit
뷰에
price, unit
보시면
variable
원고
cost,
제품과 피고
marginal
제품이
profit per
모두
unit,
2019년부터
and on the bottom
2022년까지 판매
it's
가격이
the
조금씩
defendant's
내려갔습니다.
product,
다만
and you can
두
see that the
제품
sales
다
have
5만
decreased for
원의
both
가격
parties
차이를
from
유지하면서
2021 to
피고
2022,
제품이
but
더
they
저렴하게
have
판매되었습니다.
a price difference where the defendants is
다음은 피고
cheaper
제품
than the
관련 피고
plaintiffs
회사의
by
회계 자료입니다.
50,000
이
won.
쟁점이 된 이
And
제품에
here
관한
is the
회계
financial
자료입니다.
data
보시면
relevant to the
매출액,
defendant's
원료비, 급여,
product.
운반비,
There
광고
is
선전비,
the amount of
임대료,
sales, material
지급 수수료, 기타
cost, labor
변동비가 나타나
cost,
있습니다.
variable cost, advertising cost, and all other types of financial data.
다음은 시장 점유율입니다.
And
원고,
here's the
피고,
market share for the
원고, 피고
plaintiff,
이외의
defendant,
다른
and
회사의
other
점유율입니다.
companies.
시장 점유율을 보시면 원고가 10%에서 40%까지
For the plaintiff, it
늘었고
increased from
피고는
10 to
23%에서
40%, and
43%까지
for the
늘었다가
defendant, it starts with
16%로 줄었습니다.
23%, goes up to
다른 업체의
43%, and
점유율도 원고
decreases
점유율이
to
늘어남에 따라
16%. And
2021년까지 줄다가
for
2022년에는
other
오히려
companies,
피고
the
점유율이
share of the
줄어드는
plaintiff
영향으로 다른 회사 점유율은
decreased, and
늘어났습니다.
as such, the market share of other companies have increased from 2021 to 2022.
가상의 사례 쟁점은 그
The
침해자의
issue in
양도
this
수량을
hypothetical
기초로 한
case is the
손해액
calculation
산정,
of damages
침해자의
based on the
이익액을
transferred
기초로 한
amount of the
손해액
infringer,
산정,
damages
실시료를
based
기초로
on
한
the infringer's
산정입니다.
profit,
그리고
and that
각
based on
산정
royalties.
방법에 따라서
For
산정할
each
시
method,
기여율, 침해 행위의
apportionment
사유로
and
판매할 수
circumstances that
없었던
hampered
수량이
sales
쟁점이
other than
됩니다.
infringement will be
기여율은
also considered.
침해품 일부에 특허가
Apportionment
적용되거나
issue
피고 및
looks at
광고
where the
선전,
infringer
침해
product
광고의
only
우수성, 디자인,
partially
인지도
applies the
등이고
patent, the
침해
advertising
행위,
efforts,
외의
excellent
사유로 판매할
quality,
수
design,
없었던
and reputation
수량은
of the infringing
공급의
product,
차질,
alternative products in
대체품의
the
존재,
market,
시장 점유율
market
등입니다.
share,
그리고 마지막으로
along with
침해
other
대상이
factors.
인정될
And
것인지도
whether to
하나의
recognize
쟁점입니다.
enhanced damages is another issue.
이제 중재인단을
Now,
모시겠습니다.
I'd like to invite to the stage the tribunal consisting of judges
고등법원
from
이경 부장판사님이 의장
Korea, US, and
중재인으로
Germany. We have
모의중재를
presiding
이끌어
judge Kyung
주시겠습니다.
Lee, who will be the chair arbitrator.
입장해 주시겠습니다. 대리인께서는 자리에
May we
일어나
welcome
주시기
him to
바랍니다.
the stage, and could all attorneys stand?
So, among the three judges, I'm the chair. My name is Kyung-ho Lee. We just had lunch, so I hope you don't feel too lousy right after lunch. But this is the last session of today's conference, so I hope we can still have your attention. The case sounds a bit complex, and also, as you just saw, the Korean laws have very complex language, so we try to be as easy to understand as possible. First of all, honorable judges from the US, the UK, and judge, please allow me to refer to you as arbitrators. It is my great honor to be here with you. So let me introduce our judges from Pennsylvania, District Court for Western District of Pennsylvania. We have Judge Kathy Bisoon. She traveled a long distance to be here with us, so thank you. And also from the Regional Court of München, we have Judge Anna Lena Klein joining us online. So yesterday and today, for today, despite the different time zone, thank you very much for being with us. So the two honorable judges already participated in the session 4 about damages calculation, and they generously shared with us their insight. So we were able to enjoy a lot of expertise. So thank you very much. Regarding this arbitration, moot arbitration, as you are well aware, in terms of giving an overlapping judges, it's similar to trial. But in principle, the parties, when they want to use the arbitration, and also they look at kind of a language and laws, these can be agreed upon by two parties. So like private decisions by two parties are at work here. So you can refer to the reference that we provided for arbitration in the booklet. And here, the arbitration takes place in Daejeon and is going to be governed by the patent law in Korea, and the official language are both Korean and English. And the arbitrator, as I mentioned, are from the US, Germany, and Korea. And also under the arbitration law, you can select the arbitrator irrespective of the nationality. However, originally the governing law was the patent law in Korea, but then sometimes if both parties agreed upon, then we can use other countries' law, for example, the US and Germany law, in terms of the calculating the damages. So the judges from the US and Germany have agreed to utilize their nation's law. This I will refer to Korean law. So the conference is the third of its installment, and we have judges from the first time around. We had a standard patent, and the second time we had the judges from Germany and the US and Japan as well. And Komiko, Judge Komiko participated as well, and we talked about calculating damages back then as well. So over the course of these past conferences, so just like we heard of during the session 4, we had a lot of practical issues in terms of calculating the actual numbers, even though we have a lot of theories to apply. So that's why we had session 4, so that we can hear a lot about cases. And in Korea as well, enhanced damages are recently introduced in Korea. So we were curious about other countries' situations. So here, for the court IP new practice. So hopefully this session and this moot arbitration will give us an idea about guidance for Korea to employ the concept of punitive damages going forward. And as the moderator mentioned, each party will have first 15 minutes for their argument, and then Q&A session, 10 minutes, followed by the arbitrator's opinions. And I will be the last arbitrator to give the opinion, and then we will share the judgment. So the panel of arbitrators consists of 3 arbitrators. A majority vote is going to be determine the judgment, and the ruling is going to be equally effective as the court ruling. So if you accept, I don't know if you do not accept the ruling, when we can set another date for another arbitration session, but okay, so the plaintiff, we are going to still use the words of plaintiff and defendant here. Can you introduce the attorneys?
모의중재 대리인을 소개해드리겠습니다. 먼저 원고 측 대리인입니다.
Starting with the
먼저 김정규
plaintiff's
변호사님.
attorneys, we have attorney 정규 Kim.
다음으로 김정대
We
변호사님.
have 정대 Kim, attorney.
그리고 손천우 변호사님.
Attorney 천우 손.
마지막으로 최인호 변호사님입니다.
Attorney 인호 Choi.
피고 측 대리인 소개해드리겠습니다.
Here's the
먼저 강이강
defendant's
변호사님입니다.
attorney 이강 강. Attorney.
다음으로 신동환 변호사님.
Attorney 동환 신.
다음으로 윤초롱
Attorney
변호사님.
초롱윤.
마지막으로 차효진 변호사님.
Attorney 효진차.
이상입니다.
Please refer to the reference book for the detailed credentials for the attorneys. And in the reference book, there are also the researchers who have helped put together today's moot arbitration. Now we will begin the moot arbitration on the damages for patent infringement. We will, since it begins with the claimant's claim for the next following 15 minutes, we will hear from the plaintiff.
네, 그럼 원고 측.
So let me start the plaintiff's argument. So I'm Choi In-ho. So I will go over the index here, and I will look at the damages calculated per legal provision. So basically, this case, we don't have any dispute anymore about the infringement, but still, let me give you a quick overview of this patent to help your understanding. And so this is a drum washing machine, and it is made up of 10 parts. And part number 3, a driving unit, is the patented invention at issue here. So compared to the prior art, if you look at the yellow mark, it's a motor. So motor is included in the driving unit. So in the prior art, motor is located at the bottom of the machine. So it is in order to transmit the power from the motor to entire machine, it has to go through another part. So it requires a higher number of parts. It is prone to noise and defect, so it can lower the performance of the machine. But if you look at the patented invention here, the motor is located at the center, so the power can be more directly transferred from the motor to the driving unit. So compared to the prior art, this invention solves the technical challenges. So if you look at here, so you can see the disassembled and assembled drawing, and we color coded. So stator and is inside the rotor, and if you look at the rear wall of the plastic top, that this is where the motor is attached to, and then right below a supporter is attached. Supporter is marked as red. And if you look at the patent here, so this is about the driving unit of the washing machine. Out of the 10 elements of washing machine, driving unit may be mathematically just one unit, but you cannot take such a quantitative measurement. You have to look at the actual contribution in terms of the function and performance of the entire washing machine. Given that the driving unit performs the essential role for the washing machine, and the driving unit takes only 2% of the entire infringing product in terms of cost breakdown. Even if that is the case, still, the driving unit determines the entire power transmission system structure of the washing machine. So you cannot just separately look at the driving unit. And even though the defendant's technologies are applied to this product, it is not proven yet. Still, again, quantitative separation is not appropriate here. Then let me go over the calculation. Now, let me talk about the damages calculation. Under the Article 128-2 of the Patent Act in Korea, so if the infringement is valid, then it talks about the damages calculation. And as we heard during the morning session, so we look at the sales quantity, but for infringement. If that is established, then reasonable royalty can be utilized as a royalty base in Korea. So let me talk about that. So under the Article 128-2-1, then it talks about the quantity the patentee could sell, but for the infringement. So here, just because you have patent, it doesn't mean that you have to practice the patent, but it is required that you have the production capacity and the capacity to sell the product. So here, this is the objective capacity. It does not talk about some temporary issues that may cause supply disruption or that may due to suppliers issue. So also there was a similar opinion during the morning session. And also substitutionality is not about perfect substitutionality. It is about if there is any possibility where the technology can be the patentee's technology can be utilized by the infringer, then it is considered. And also this is a table that we came up with about the quantity of transferred unit. So the quantity that the plaintiffs could sell but for the infringement. So here was about 35,000 for year 2019 and 60,000 for 2020. These numbers need to be included in the damages calculations. Regarding the per unit, the profit per unit, so the patentee's price per unit is the starting point, and then we look at the sales cost. So it means additional cost that the patentee probably paid to create the sales. So you deduct this amount from the profit. So that is the marginal profit concept. So as you can see here, this cost is related to the production and sales activities. And oftentimes we utilize the Bank of Korea materials in the area of home appliances. When you look at the variable cost of revenue, you can see the percentage here. So we can see that 38.44% is the marginal profit ratio for 2019 and 40.19% for year 2020. So if you utilize these numbers for the marginal profit ratio, then overall the marginal profit is 20%. So this is much lower than the Bank of Korea number. So we think this is an appropriate number. So because of this, regarding the quantity of infringing products within the range of remaining production capacity, so when we look at the marginal profit per unit, then it's a 4.2 billion in 2019 and 1.1 billion for 2021, and the damages can be around 8.3 billion in Korean won. And the defendant claim, we'd like to make some counterclaim. So regarding the quantity, the circumstances where we could not sell above for infringement. So these circumstances means that the infringers had an ability to sell, and also there was the infringer's sales activity and trademark or advertisement activities. All these are some non-relevant, non-patent relevant factors that might contribute to their sales volume, and also some circumstances that the infringer's other IP rights were exercised. However, the defendants needs to prove this. And also, when you look at the market share, the plaintiff's market share increased, but other companies' market share went down. And the defendants is arguing that there are other competing products in the market, but they have not proven that there are non-infringing products. And also, if you look at there's not meaningful data about the contribution to the market share. If you look at this table from 2016 to 2020, the defendant exercised a certain amount of advertisement, and if you look at the correlation between this advertisement cost and the actual sales, there's no significant relationship. And for example, advertisement cost went up by 20% in a certain year, but the sales volume did not increase proportionally. And also, if you look at the design of the defendant, they are arguing that their design made a contribution to their sales volume, but that contribution seems to be insignificant. And if you look at the consumer's preference, they don't look at the film exterior design of a washing machine. they don't look at it as a deciding factor to choose a particular washing machine. And also in a washing machine, it's located in laundry room where there is a water pipes, water is available. So it's hidden from a plain view. So design is not a critical factor to determine the sales volume. And also the defendant is using the survey as a brand awareness evidence. But if you look at the survey, looks at only a certain period that does not cover the entirety of the infringing period. And also, if you look at the survey content, it's just about whether the respondent knows the defendant's product name and product design, and it doesn't ask about whether the defendant's product's design had anything to do with their purchase decision. Although defendants has the burden to prove whether their design or brand awareness had a significant contribution to their sales, they failed to prove that. And also, the plaintiff, therefore, we can only prove all the profit per unit for the quantity, the transferred quantity, and also the quantity that they could sell, but for infringement. And under the, let me talk about the Article 128-2-2. So basically, it is about non-infringement volume. So the volume that goes beyond the production capacity of the plaintiff, hence the volume that the plaintiff could not sell. So here, the reasonable royalty is applied. So if you look at the clause 5, so among the infringing quantity of the infringer, we looked at the volume that goes beyond the plaintiff's production capacity. So here we also multiply by the marginal revenue of the defendant. And when we need to apply the reasonable royalty, and according to many case laws, we looked at the common royalty in Korea, and also we looked at existing license agreement of this patent, and then we looked at the royalty rate of the existing license agreement. But here, if the legitimate but in this case, the infringer should not be better off than a legitimate licensee. So in this case, here, so 4% of the common royalty rate is applicable. And here, the plaintiff in year 2019 had a license agreement with third party where 5% the royalty rate is applied. So we believe that at least 5% of reasonable royalty rate should be applied in this case. And I understand that the defendant is arguing for 0.3%, but if 0.3% is applied, then who would want to enter into a legitimate license agreement? So according to the this methodology, we come to 2.93 billion Korean won, and if we add this with the previous amount, then you have the sum here. And according to Article 128-4, so this is about the infringer's profit. So the defendants, depending on the defendant's quantity, and also we multiply that by the profit per unit, and also we look at the cost as well. So so Article 128-4 damages. So Article 128-4 damages. So here, how are we going to calculate the infringer's profit? So we looked at the net profit and marginal profit as well. But marginal profit is what is commonly utilized in Korean court. So this is what we are going to use. And I'm sure everyone here is familiar with the basis for that. And so we calculated the marginal profit here. We looked at the defendant's accounting documents. So deducting all the material costs, other costs are fixed cost. So ultimately, according to the Article 128-4, we concluded at 27.7 billion, and so marginal profit is about 22% to 38%. So this compared to the Bank of Korea's overall industry data, this is a bit higher. And also the defendants is arguing that regarding the Article 1280-4, they're saying that their sales volume exceeds by far the production capacity of the plaintiff, so this clause cannot be applied. But according to the this Article 128-4 is different from Article 128-2, so it is not limited to the production capacity of the plaintiff. So the defendant's argument here cannot be accepted, and the advertisement cost and coefficient is applied here. So this is all variable cost. So this is their argument, the defendant's argument. But if you look at the actual cost items in year 2022, we don't have data for 2022. So we cannot trust the data submitted by the defendant. If you include the data from 2022, then you can see that there's no correlation between the increase in the sales volume and these kind of cost items. Now let me talk about the Article 128-5 damages. So regarding the sales volumes, a reasonable royalty and 5% as a reasonable royalty rate, this is what we argue for. So this is the numbers that we got from this. The damages 4.84 billion in Korean won under Article 128-5. And next, and also there is an enhanced damages recently introduced. I want to talk about whether it is applicable here. So this is the clause Article 128-8 and 9. So up to the triple amount of the damages recognized, you can award it as enhanced damages. And so these are some considerations to take into to consider. And for example, the culpability as well. And also culpability was one of the motivations to legislate enhanced damages. So we need to see whether there's a culpability. And under item 9, there are these factors as well. So defendant does not dispute this. But if you look at each clause circumstances, let me go over the situation. So from Article 128-9-1 through 7, it talks about whether the infringer maintains a superior position. And so when the infringer has a superior position, it is much more culpable because you take advantage of a financially inferior, smaller company. So we want to protect the small and medium-sized company here. There is a rationale of this clause of the law. And this is very applicable to this case because the plaintiff is a newly formed company based on this patented technology, whereas the defendant is a large company that has a superior market position and has a much longer operation in the market. So if you you have their market ranking here, and given that the item 1 and 7 can be the 1 and 4 can be considered as an enhanced damages consideration. And now we have 4 factors or four facts or circumstances to consider to determine the enhanced damages. For example, the defendant knew about the existence of the patent before they infringed it. And this, if you look at the prosecution date, you can check that. And also, the plaintiff, right after they filed for this patent, they already began producing the product and selling that in the market. So the defendant must have known about the patent and must have known about the sales activities of the plaintiff. So then when the defendant was started infringing this patent, they must have known about this fact. And also, the defendants are arguing that they had a legal opinion. But if you look at the substance of the legal opinion, then the lawyer first was not a patent lawyer. So if you look at the substance of the legal opinion, there needs to be some comparison of the infringing products and the plaintiff's product, but there's no such comparison in the defendant's legal opinion. And even that, the defendant had no awareness of an issue of the legal opinion that they got, and they just continued to infringing. And also, if the defendant also even didn't try to design around, so there's no effort by the defendant to design around. Only after they received the warning letter from the plaintiff, then they stopped. They didn't even stop. And also, regarding the enhanced, and so this factor cannot have an impact on the enhanced damages. If you look at the Supreme Court ruling, if two patents are in conflict with each other, then a prior patent takes precedence according to the Korean law. So even though the defendant has their own patent technology utilized in this product, it is not much relevant in this case. And also, so this can be considered as a positive factor for rendering enhanced damages. And now let me talk about whether the patentees, how much. Now, also according to the Patent Act, the infringer's profit can be considered to calculate enhanced damages. With this infringement, the defendant experienced a much larger profit, whereas the plaintiff experienced a lost profit. And also, we need to look at the duration of the infringement. So for about 3 years, this long period of 3 years, the defendant continued infringing. And also, even though defendant was ordered summarily to pay the fine, but even though they stopped the production at one point, but we are not sure if they would have done so without such a penalty of fine. And now let me talk about the penalty, the fine. So the investigative agency, they gave a summary order of 4 million won in fine, but the defendant refused to accept that and actually chose to go to formal trial. And 4 million fine is so insignificant compared to the damages experienced by the plaintiff. So the fact that they refused to pay the fine is a positive factor for enhanced damages. And also, even though they received a warning letter from the plaintiff, the defendant actually increased their production volume of the infringing product and even had more advertisements of the infringing product. And also, we cannot say that the defendant did their best to give a remedy to the plaintiff. With this, we believe that triple amount as enhanced damages is called for. So in conclusion, so this is the amount that we argue for with time limit. We will conclude here. Thank you very much. Okay, thank you very much. So here 83.25 billion. So the secondary request 33.75 billion. Secondary request to 14.52 billion.
Now, the plaintiff took up a lot of time, so now the defendant has the time for argument until 2:45. As the plaintiff, we will give our pleadings following the provisions of the Korean Patent Act, starting with Article 128, Paragraph 2. So, although it is seen as lost profits, but if there were circumstances where the sales were hampered, then that would be reduced, and the causality is used to limit the amount of damages. If there are circumstances that hampered the sales, it would be the marketing efforts, advertising efforts, the superior quality. So such sales that have been incurred regardless of the patent, and also the existence of competitive products in the market and other IP rights included in the products. In this case, all of these factors are relevant. And in this case, the market share of other companies have constantly been hovering around 30%, and the sales have been suspended in 2021, and afterwards, the market share of other companies have increased to 44%, which shows that there are multiple other competing products that could act as substitutes. Therefore, out of the transferred quantity, only the sales that are within the capability can be sold. And in 2019, more than one other company, the licensing agreement has been completed. So, in the market, it is evident that there has been substitute products. Instead of the imitating product, in fact, the defendant's product has its unique characteristics with 19 other IP rights, which can drive consumer demand. Therefore, out of the transferred quantity, only the quantity within the market share of the plaintiff can be sold. Therefore, the market share of other companies should be considered, which is not the quantity that the plaintiff could have sold, so it should be reduced from the transferred amount. And also, the decrease of market share due to other companies, and besides that, the apportionment of the patent should be considered. Out of the profits of the infringer profit, part of it is due to the contribution of the infringer. So, out of the quantity of the products that the plaintiff might have sold, in fact, this could be a limiting factor. About the apportionment of this patent, we will look into it deeper later on, but this driving unit is only one of the 10 elements in the drum type washing machine, and there are 19 other IP rights that are greatly influencing the consumer's purchase decision. And there is a design, a registered design. Therefore, the patent apportionment would stand at 1%. So the quantity accounting for other 99% is an amount that could not have been sold even if it weren't for the infringement. After that reduction, the remainder of transferred amount is shown here in the table. In order for the damages to be recognized, in fact, the actual product unity that has been sold should be deducted from that of the production capacity, but the plaintiff sold all of its the units within its production capacity. So in 2022, the remainder unit would not be incorporated in the damages. So 55 million would be the damages calculated after the first provision. And now we will look at the second paragraph of Article 128. Here, if there's a deduction due to going beyond the production capability of the plaintiff, that could also be reduced, and this shows the number of units that has been reduced. For reasonable royalty, we have to look at the technical value of the patent and the reasonable royalty for comparable technology. So we need to take a comprehensive review of all the factors, and 0.5% seems to be the reasonable royalty fee here. So that would result in 482 million, and anything that goes beyond this amount cannot be recognized. We will look at paragraph 4 under the Article 128. If we look at this provision, it reduces the burden of proof. So it doesn't recognize the damages that is not directly due to the infringement. Therefore, in this case, out of the profits of the infringer, what goes beyond the production capability of the plaintiff would be reduced. And about the meaning of the profits of the infringer, it refers to the net profit. If you look at the table, from 2019 to 2022, the net profit rate of the plaintiff was in minus, so there is no damages on the part of the plaintiff. And even if the plaintiff was right and recognize this marginal profit, the aggregate amount is a mere small portion of the infringer's profit. And in 2022, the plaintiff sold the entire amount of its production capacity. Therefore, no damages have been incurred to the plaintiff in 2022. So the marginal profit acquired by the infringer from the years 2019 and 2021, that would be applicable. If the revenue increases, variable cost increases in tandem. So between the cost and the revenue, there should be a correlation coefficient, and if that is more than 1, then that would be a related variable cost. But from 2019 to 2021, the revenue of the defendant and the profit, if you look at the coefficient, we can see that the raw material, advertising cost, and rents and commissions paid are relevant variable costs. The plaintiff argues a different coefficient, but in calculating the marginal profit, if we only need to consider the accounting data until 2021, and due to unprecedented inflation, the raw materials and labor costs have exponentially soared. But despite that, the defendant wasn't able to increase its product price. So if you take that into consideration, then the year 2022 must be excluded from the calculation, and that is only justifiable. So with variable cost refers to those with plus coefficient, and the sales amount that goes beyond the production capacity is rebutted, then 260 million is the defendant's marginal profit. And within that, if we consider apportionment of the patented invention, then the damages would be under 2 million won. We will take a look at the apportionment ratio. If we look at the Supreme Court case of Korea, it is as on the slide, and if we take that into account comprehensively, it could be summarized as such. There are two factors to be considered. First is the degree of relevance between the patent and the infringing product. With that, the indispensability of what has been infringed on and the importance price ratio, quantitative ratio can be taken into consideration. And the second factor is the characteristic of the defendant's product. The portion of technical features unrelated to the patent invention in the sales, the overall brand recognition, market reputation, and excellent quality can be considered. Then, based on that, we will look at the apportionment ratio. The driving unit was relevant to the patent. It is one of the 10 elements. If we look at the price ratio, the unit cost of the driving unit is only around 10,000 won. So it takes up only 1.7% to about 2.2% of the total price. We will take that into consideration along with other circumstances. First, the defendant has a bigger business in the same industry as the plaintiff. So when it comes to electronics, the defendant possesses much know-how and technological prowess. And there were 19 defendant IP rights in the product, which encompasses elements that affect the function of the washing machine. And to sell the washing machines, the design has been registered by the defendant on 2017. Due to the ingenuity of the design, the defendant swept prestigious design awards from both home and abroad. If you look at the design, it has great awareness among consumers, which can be verified through the survey. We can look at the survey results. The question was, have you ever seen this design before? Are you aware of the design? And 60%, which is the majority, said yes. And the second question was, can you recognize the product? 54% said yes, and 39% of the respondents were able to specifically name the product name drummer. Over the 4 years, the defendants spent 8.5 billion Korean won for advertising the product, and the price of the defendant's product was always about 50,000 won cheaper than that of the plaintiff, and this is 10% of the total price of the product. So it means the defendant's product is 10% cheaper than that of the plaintiff, which is enough quality that drives consumers' purchasing decision. If we now look at the apportionment ratio, given all circumstances, it is reasonable to set it at 1.7%. Then marginal profit, about 200 million won times 1.7% would end up at around 2 million Korean won. Now we will look at damages under Article 128, Paragraph 5. It says that the patentee may claim as damages the reasonable royalties amount. If we look at the Supreme Court cases precedents when deciding the reasonable royalty, it is not one-size-fits-all principle, but all circumstances are taken into account, such as the technical value of the patent or licensing agreements with the third parties or the royalty of a comparable patent and various circumstances in the argument. Then we will look at the calculation of damages according to this provision. First, the objective technical value of the patented invention and the form of usage by the patentee is considered. There are 10 elements that comprises the washing machine, and the patent was merely regarding one out of those 10 elements, the driving unit. In 2021, due to disruption in chips supply, the patent was not actively used by the defendant. So the second element is the royalty of the same kind of patented invention in the field. The royalty rate for general electronics products is about 4%. The plaintiff concluded licensing agreements with other parties in 2019. At the time, the rate was somewhere between 1% and 5%. So the reasonable royalty rate, it has to be somewhere in that range. But given the circumstances, it should be settled at the reasonable rate. And let's look at the various circumstances during the entire trial. The defendant records much higher revenues than the plaintiff. It has a great brand power, and the design rights have swept awards and have actively been advertising the design. And its price is cheaper than that of the plaintiff. And the defendant did end up infringing on the plaintiff's patents, but made its best effort to avoid infringement. It researched the scope of the claims of the plaintiff's patent and believed that the employee's invention was a new idea that was not in scope of the patent at issue. And they also received the council's advice that it was not an infringement. So they did a double verification to make sure they weren't infringing on the plaintiff's patent. But as the issue was not resolved, it voluntarily suspended the production in May 2022. Considering all these factors, the defendant had a great technical prowess and did not rely on the plaintiff's technology. They ended up infringing, but stands at a different situation than other third companies. So the reasonable royalty rate in this case is about 0.5%. If we calculate based on that, about 480 million Korean won seems to be the damages. Now, could you wrap up in 5 minutes? Thank you. Now we will look at paragraph 8 of the same article and how enhanced damages does not apply to this case. The provision says that when there is willful infringement, enhanced damages may be applied. We do not have relevant precedent, but it is punitive in its nature, so it has to be strictly and narrowly applied. We also have criminal sanctions. So if we do not narrowly interpret this provision, it may end up in double penalty. And there are cases where this is not applied. And now we can look at all the factors that should be taken into consideration when making such judgment. The U.S. Also states that this is applied in reproachable cases, and this is a list of factors that should be accounted for. And these factors under U.S. law and the factors in Korea's corresponding provision, the enhanced damages does not apply in this case. Now, subparagraph 1 says whether the infringer is in a superior position to the patentee. The market share of plaintiff and defendant are similar, and other company has a superior position, and the plaintiff did not abuse its standing in the market to infringe. And second is willfulness and awareness of the infringement. It was not, defendant did not make a dead copy. It made a comprehensive review to avoid infringement. The infringing product, when we look at the getup of it and the internal parts of it, it was the council advised that it was not an infringement. And there, before the summary judgment, the plaintiff did not receive any official decisions on the matter of infringement. It made efforts both internally and with independent experts to avoid infringement, so shows goodwill of the defendant. Subparagraph 4 and 5 is referring to the economic benefits to the infringer and duration of the infringement. But there it shows the damages, and if there are no separate additional damages, then we shouldn't recognize enhanced damages in this case. There are multiple competitors in the industry, and the market share of the plaintiff have continuously grown. On the other hand, the net profit for the defendant was in the reds, and the marginal profit was minimal, and the defendant did not gain any additional and unusual profits. And subparagraph 6 looks to consider the criminal monetary penalty for the infringing act. And there was a summary judgment for 4 million Korean won, so the reason here does not apply in this case for enhanced damages. Subparagraph 7 is the financial status of the infringer. The legislative purpose is to decide whether it is justifiable to fully enforce against the plaintiff. And well, the defendant is a big company, so there is no concerns whether it will follow through with the judgment or not. And subparagraph 8 is with regards to the level of efforts the infringer exerted to provide relief, and voluntarily it suspended even before any orders were given. So it did all within its power to provide relief. Considering all other circumstances, it is unjust for enhanced damages to be applied. So it was difficult to determine whether the infringing product fell under the scope of the patent because that was the opinion that it received from external review. Also, during the arbitration and litigation proceedings, the defendant did not delay or hide any evidence, so it is not reproachable. And in May 2021, before it received the notice, the defendant showed goodwill to avoid infringing and was not aware of the fact that it was infringing on the patent. So the usage before the notice cannot be reasons or grounds for enhanced damages. In conclusion, there is no willfulness proved in this case, and there is no reproachability that is established, which could serve for enhanced damages. And as you can see on the table, even if you incorporate the factors in paragraphs 8 or 9, there are no grounds established for the enhanced damages, and even if it is, the scope should be minimized. I would like to tell you the conclusion. The amount of damages that can be recognized under Article 128(2) is around 500 million won, and the estimated amount of damages under paragraph 4 would be about 2 million Korean won, and under paragraph 5 would be around 483 million, and no enhanced damages should be awarded. Thank you. So 83 billion won is argued by the plaintiff, and defendant is arguing around 2 million. 500 million. So we are showing a drastic gap in their opinions. So now arbitrators are going to pose questions.
My first question is for the defendant. Given that your market share was only 23.33% in 2019 and decreased to 16% in 2022 after you stopped utilizing the infringing component, doesn't that demonstrate that your sales were motivated by the infringing component?
With regards to that point, well, we understand that the patent has its favorable qualities, but I could go into further detail. Well, we have our 19 IP rights in the product. It reduces the sound of the noise of the driving unit. And we have a patent specifically related to the driving unit. And for the defendant product, the registered design was applied. The plaintiff said that since it's being used in as a washing machine, the design wouldn't be as important as other products like televisions. But in reality, Well, the most important point is the shifting in the washing machine market to the get-up of it and the appearance of it. So this is a comprehensive product that is used for not only washing but drying and as a part of the interior. So the consumers' purchasing design is greatly swayed by the aesthetics of the products. So our IP rights and our design had a great role.
This question is for plaintiff. The problem does indicate that the patent at issue, as well as the registered design, was a driver of customer demand. So how can you totally discount the registered design?
네, 저희가 변론 과정에서 간단하게
Well,
설명을
during our argument, I was
드리긴
brief on this, but
디자인적
the
요소가
design element, some products have direct relationship between the design element and its sales. But in the case of drum washing machine, people do not buy a washing machine just because it's pretty to look at. People buy washing machine because the machine cleans well and dries it well. So it's more focused on the function and performance of the product when the customer makes a purchase agreement. So that is our argument. Thank you.
그러면 이어서 우리 저지 클라인
Now, Judge Klein, do you have a question? Do you have a question?
Yes, thank you. Yeah, relating to the plaintiff, you mentioned that the infringer shall not be better off than a licensee, and thus you would relate or refer to the 5% license that you provided in a license deal closed in 2019. But would the circumstances of this license deal be comparable to the figures that would be inserted in the case at hand? Because you also had, if I am correct, you also had license deals where only a 1% license rate was provided. So are those factors, are those circumstances really comparable? Thank you.
예, 말씀하신 것처럼
As you mentioned, so the license rate, well, it's in the range between 1% and 5%. But in this case, the most appropriate royalty rate is 5%. That was our argument. Yes. So 1 or 2% rate, it was applied with a party that the plaintiff had a special relationship. For example, the deal structure allowed the plaintiff to get profit not just from the license, but if you look at the license agreement between the plaintiff and a complete third party, then 5% was applied in such license as a done practice. So given that, we argue for 5% as a reasonable royalty rate. Thank you.
Judge Klein, do you have another
And one question to the defendant. I would like to ask the defendant for a specification of which are called other variable costs concerning to the infringer's profit and concerning to the questions if those other variable costs would be abducted or deducted. Thank you.
It's a very important question. Thank you. The other variable cost refers to various costs. We refer to it as other variable cost. Well, first, the sales commission that is given to the sales channels and the storage cost for the parts and components and the import cost, customs cost for the imported parts and components are included. In 2019, the variable cost compared to the revenue is very high. So I believe that you must have picked up on that. In the year 2019, defendant aggressively seek to expand its market share, so it gave higher prices to our suppliers compared to our competitor companies. Therefore, you can see that there's a correlation between these costs and our revenue.
Okay. That's kind. Yeah. 저도 한 가지만 좀 피고치게
I also have a question to the defendant. So, when you are calculating the damages,
피고 제품 양도 수량 전부를
the entire transferred quantity is not deemed as the lost profit of plaintiff. Only the corresponding amount, the amount that corresponds to the market share of the plaintiff, is seen as the lost profit of the plaintiff. But is market share really sufficient grounds for to establish your argument? Could you give us more theoretical grounds on that? We have other grounds than the market share. So we said that the market share should be implemented because the infringing product has its own strong points. So that leads customer purchasing decisions, and without that, then the sales quantity could be divided between the plaintiff and other companies. So if our product was 100% counterfeit, then by not producing the defendant product, the entire sales would be transferred back to the plaintiff, but our product has its own strengths. So that became another independent option that could impact the sales of the plaintiff and other companies. So we have our own IP rights and our design that is registered as a right in our product, and there are other comparable products with under licensing agreements. Okay, I see.
Now, so this has been the Q&A session with the arbitrators. So the closing argument, starting from the plaintiff, please limit the argument to 5 minutes. Thank you.
네. 그 정리하는 의미에서
So as a closing argument, we'd like to talk about one case. There's a company A, and company A is in the market that is dominated by large international company. So company A is a new company that is challenging the dominant players. And company A has technology, really innovative technology that is critical to the overall function of the product, and patented this technology. And with this patent technology, they're revolutionizing the market. There's a company B, and company B has been a long time incumbent with a strong market position, ranking 3rd in the market. So it's a large company, established company, but company B, while they're monitoring their competitors' technology, they caught sight of the company A's patented technology. What options were available for company B? As you are well aware, in this case, company A is the plaintiff, company B is the defendant. And what you all know what kind of choice company B made here. So in less than 6 months after the patent was practiced by the company A, they utilized this technology to produce their own washing machine. And then also they even they had really just a formality. As a formality, they had a legal opinion, and they didn't even try hard to design around the patent technology. And also they even tried to expand the production capacity, production volume, utilizing this patent. And only after there was a warning letter and a fine penalty as well, then company B decided to stop the production, but that was already long overdue. We all know how much time matters here, and also because of this infringement by company B, company A was deprived of the time opportunity where they could have built their brand awareness and market position. And also, despite the summary judgment of a fine penalty, company B even refused to pay that and even brought this case to court. and arguing that they didn't infringe. And also, they are saying that their product is a composition of a various non-infringing technology and their own IP right. So they are even arguing for below 1% of royalty rate. But Company A, we have a question to ask Company B. Company B already has such a superior positions and resources. Why did they then choose to infringe upon Company A's patent? The reason is clear for us. It is because despite the existing patent technology that Company B already has, they couldn't close the technology gap without utilizing Company A's patent. That is why they infringed. And if you look at the competitors' market share, they declined while Company B utilized the Company A's patent technology. And here, in terms of calculating the damages, we need to look at the sales volume of the defendant B and also profit also. But they're also artificially trying to lower down these numbers. And also, the plaintiff as well has already entered into license agreement with a third party. So when Company B knew about this patent, they could have chosen to have a legitimate license agreement with Company A, but they didn't choose that path. So Company B, so if we acknowledge damages only below the reasonable royalty rate, then we would economically incentivize companies to violate other companies' IP rights. And here, Company B is even a large company, and they're now they have that if that is allowed in the market, then the large company with established market position will not be incentivized to respect the new entry companies' technology. In Korea, we want to protect the IP holders, and 2019, for intentional infringement of IP rights, we allow enhanced damages. And so we believe that this is a really milestone case to utilize the concept of enhanced damages. So I hope that the honorable arbitrators will consider all these factors, and I hope that you will lean favorably towards our amount.
We will now move on to the final argument of the defendant. Here, apportionment is at issue. The defendant will counter the arguments made by the plaintiff first. It is about the patent itself. The plaintiff's technology is not a source technology, but only an advanced technology. Therefore, it does not have technical value as high as a source technology. Defendant also has 19 patented technologies, which reduces the noise and the loss of driving force, and which prevents the entanglement of the laundries. So we had our own technical prowess, and about the washing machine, we had various technologies that were implemented. So the patent of the plaintiff was not an indispensable element for the defendant's product. And second, it's about the advertisement cost. As soon as the defendant started advertising, the revenue increased in the next year by 56%. 56% increase is a huge achievement of advertising activities. And for washing machine, it is not a cheap product. It is a high-priced electronics, so consumers do not buy immediately after watching ads. They very cautiously examine the product and take time to decide on their purchase. So the revenue did not increase immediately after the advertisement, but there is a time gap. And third, there is the design element. The defendant's design was a driver for the growth, but the plaintiff disagrees. But if we look at the case in Korea, the bespoke of spoke and objet of LG with our premium design products, they are not that different from cheaper products in terms of performance, but they are priced twice or 3 times higher only because they have great aesthetics. So that has to be taken into consideration. And fourth, there's the survey. Plaintiff says that the defendant's survey does not serve as solid grounds, but we have put forth the image of the defendant's product, which was perceived by the consumers as the defendant product. But this was a survey that was carried out to this sample that is meaningful. It is impractical to conduct a survey to the entire national population. And it is evident that the design played a critical part in driving consumer demand. So please consider that and deliver your arbitration award. Thank you for the very convincing final arguments from the two sides. It really feels like we're actually in the middle of a real arbitration. Thank you. Based on the briefs that were submitted, the tribunal have discussed. So I would like to ask each of the arbitrators to deliver your opinions based on the practice and legal system based on your countries. So we will start with Judge Klein.
Thank you. So I would like to stress in the beginning that my opinion is strictly personal. This had nothing to do with my court. Also, I do assume that the German law applies. I would also like to mention that I do estimate in my following opinion much more than I would usually during a normal court proceedings in Germany. Probably I would need to see much more facts and proof and hear maybe an expert or witnesses to arrive at a formal decision later on. But I will estimate here for the sake of the arbitration court. So my calculation, first to damages based on royalty. Like I explained earlier, there is the possibility to get royalty damages based on German law. The relevant aspect is the royalty amount reasonable contractual partners would agree on when arranging a license contract, presuming the license, the usage would have been allowed. So I've explained all this earlier. I'm going to skip the backgrounds of German law here. If royalty damages are claimed concerning the infringement by a complex product, like it is here, where only parts or composites of the products are patented, the courts will have to determine the adequate royalty allocation base and the adequate license rate. Now, in casu, considering this legal background concerning the royalty base, royalties should be calculated based on the washing machine as the whole unit. There is no indication that smaller parts, especially the driving unit, protected by plaintiff's patent, would be considered as the adequate royalty base by reasonable parties. It seems that production costs of the driving unit are relatively low, whereas its effects are relatively important. And the royalty of 4% for the general electrical product patent applies, in my understanding, to the whole product as well, as do the royalty rates and the license agreements the plaintiff entered into. Other factors would need to be considered when establishing the adequate licensee rate. Here, considering the rate, comparable license agreements could guide the court to an adequate royalty rate. The plaintiff entered into several license agreements, we talked about that, providing for rates between 1% and 5%, and the license rate for the general electronic product patent is 4%. This could also be seen as some kind of guideline for this case. And it's also consistent with the license contracts that the plaintiff entered into. However, since the license agreements the plaintiff relates to provide for a license rate between 1% and 4%, the plaintiff's brief show that a 5% license rate is not applied in each and every case. So without further proof, the court probably would not consider the highest rate as the adequate rate. The court must also consider other factors when determining the license rate. It suggested that the design of the defendant's product and the product price to have an influence on the customer's willingness to buy the defendant's products. Also, the plaintiff was a new company in 2019, but significantly raised its market shares until 2022. Now, the driving unit covered by the patent is only one of 10 parts, but it does have an important technical effect and substantially adjusts the efficiency of the driving unit. Thus, considering all these factors, I would arrive at a 3% license rate as a point of reference for an adequate license rate. And we talked briefly about the possibility of taking the 5% rate as a higher rate, but I would need further proof and maybe also the laying open of the certain documents to really arrive at a rate of 5% in this case. I would at the same time not follow the defendant's argument and set the license rate at only 0.5% because the defendant has not proven to the court that the factors the defendant mentions would have been taken into account when entering into a hypothetical license agreement. So I would need the provision of license agreements which relate to comparable products with comparable factors where the license parties actually considered those aspects. So I would say 3% is an adequate rate. And if you apply this license rate of 3% to the revenue, I would arrive at a sum of 2,902,500,000 kWR. To the infringer's profit, the patent holder may claim infringer's profits which are based on the infringement. So like we discussed earlier, there must be some kind of causal determination between the infringement and certain profits. The profit needs to be calculated using the adequate base or the unit of the sold product. If a complex product is at stake, like we discussed earlier, and the infringed patent covers only part of this product, the right amount usually cannot be calculated mathematically. Rather, the court needs to estimate what the right amount would be. And in doing so, the court needs to take all factors into account to really estimate the right amount. Here, variable costs need to be deducted when calculating the profit. I would assume that material costs, shipping costs, advertising costs, commission expenses, and also other variable costs, because defendant explained to me what other variable costs are, relate to the infringing product and are thus deductible. Labor costs and rent fees, those costs could be partly deductible if they are directly related to the production of the infringing products, but here there's no self-explaining correlation between the labor costs and the amount of sales. So I would not deduct those. Now again, since the infringed patent only covers part of the sold unit, the court needs to establish the share of the infringed patent's invention relating to the overall profit. Here, I do consider the following factors. The patent only protects one of about 10 parts in the washing machine. The patent was new when it was infringed. The patent protects a substantial invention, which allows for a more efficient procedure. On the other hand, the infringing product also used 19 patents from the defendant's side. The defendant's washing machine has a unique design, like we talked about earlier. Also, the defendant was a known company, and the price of the defendant's washing machine was quite lower than the plaintiff's one. So considering all these factors, I would arrive at a share of 20%. This estimation is mainly based on the fact that the plaintiff, as a new company selling at a higher price, so being at a disadvantage rather, was able to significantly raise its market share from 2019 to 2022, even considering those disabling factors. So considering the well-known brand and design of the defendants, this suggests, I guess, customers' interest in the technical involvement the plaintiff's patent offered. So I would calculate the following: revenue minus deductible costs, like I explained. I would arrive at a profit and then take the 20% share thereof, and this would be a total of 2,478,400,000 KRW. So then, lost profit. Under German law, it's possible to get lost profits. Lost profits are those profits that a patent holder would usually have gained had the infringement not occurred. The court needs to establish a causality between the infringing act and the patent holder's losses. Court also needs to establish the amount of the lost profits. The plaintiff usually needs to prove the infringing act, his losses, the causality. However, the court may estimate certain numbers if it's not possible to really mathematically calculate the losses. The court may also assume lost profits if it's more probable than not that profits would have been gained had the infringement not occurred. To my calculation, based on the fact that the plaintiff was a new company in 2019, the court cannot compare what we would usually try to do, the sales figures of 2019 and the years before that. So considering here the fact that the patented invention presented a significant technical development, the defendant is a known company and sold the infringing product at a lower price, and the plaintiff was still able to raise its market shares, the court assumes that the plaintiff's profits would have been higher if the infringement had not occurred. I may not assume that all of the defendant's profits would have been made by the plaintiff as well, since there are other competitors in the market, also licensees of the plaintiffs. There are several possibilities one could estimate the share of the profits, I guess. I think it's reasonable here to apply the market shares, excluding defendant's products, the market shares point. They might be distorted by the infringement, but I guess it's the easiest and most practical way here to calculate the lost profits. So I would arrive at, if you deduct the sales capacity of the plaintiff to provide more machines than he actually might have, and then he actually did sell, I would arrive at a sum of 1,390,000,000 KRW. I do not arrive at diverging figures based on the defendant's arguments. Since the plaintiff's patent invention presented a substantial technical development, the court is not convinced that there were multiple products that could replace the plaintiff's product based on the market shares alone. Concerning the plaintiff's licensees, the defendant has not explained how large their market share was, nor has he requested information of the plaintiffs concerning the licensees' market shares, so I would not consider this argument as successful. Based on the estimation I explained earlier, I would not set the apportionment rate at 1%, but only at 20%. We do not have enhanced damages under German law, so I skip this question. So also damages cannot be combined under German law, like I explained earlier. So I would arrive at a total of damages based on royalty. I would arrive at, like I said, 2,902,500,000. Based on infringers' profits, 2,478,400,000. And on lost profits, 1,390,000,000 KRW. Thank you so much.
Thank you very much. So, Judge Klein, so in Germany, a reasonable royal rate, a lost profit, and also the infringer's profit are all considered in calculating damages. So, thank you very much. Thank you very much for suggesting specific amounts as well. Now, Judge Bisun, so from the U.S. perspective.
Thank everybody for their arguments here today. As I noted earlier in the previous session, the United States does not recognize infringer's profit as a method of calculating damages. A few differences I'll point out. In the United States, the date that plaintiff first notifies a defendant of its claim of patent infringement is the date that damages start. And so while there is some information in the record concerning the possibility of damages for 2019, in the United States, those would not be calculated, and I did not use them for the purposes of my analysis here. As I mentioned in our prior session, there are two methods of calculating damages in the United States: lost profits and reasonable royalty. I also mentioned earlier that in some cases, this being one of them, there might be an opportunity for a hybrid calculation because an analysis of lost profits would not fully make a plaintiff whole, and that's what I find here. With respect to lost profits here, there are a few elements that I would look to in order to come up with an award: the demand for the patented product in the relevant market, the absence of acceptable non-infringing substitutes, that plaintiff had the manufacturing and marketing ability to make all or part of the infringing sales actually made by the defendant, and ultimately the amount of profit that plaintiff would have made were it not for defendant's infringement. In this case, with respect to two of those elements, the non-infringing substitutes and the capacity of the plaintiff to make the product, those each affected my loss damages calculation, because the problem assumed that there were other substitutes in the market, other competitors in the market who had a significant market share at various points in time. And also there were points in time that plaintiff's capacity to make the product would have been impacting their ability to argue that that defendant's sales would have gone to the plaintiff. Ultimately, I used the plaintiff's market share as a guide for the likely sales that would have flowed to plaintiff given the competitors in the market. So in this particular case, the ultimate calculation of lost profits amounted to 750 million won. Because lost profits only account for a portion of the infringing sales, however, I did consider a reasonable royalty. And as I mentioned earlier, that there are a number of factors that go into the calculation of reasonable royalty, and I won't burden everybody by going through those right now. But in this particular case, the two things that really motivated me were the 4% general electronic product patent rate, so an established royalty in the field, as well as the licensing agreements with other companies that were made for the patent at issue, with royalty rates ranging between 1% and 5%. I agree with Judge Klein that it would have been useful to the evaluation to have some knowledge as to what the nature of those agreements were with respect to licensing. You know, were they exclusive? Were they for a particular time? Those sorts of things, and what the nature of the license was exactly. But with those two things said, I thought that a 4% royalty rate would be the appropriate rate here. As to apportionment, that's where things got a little tricky for me. There wasn't much in the record that spoke to anything driving demand for the product other than the patented issue and the design element of the particular product. Notwithstanding the fact that the defendant had 10 other components to the machine and other patented components in the machine, in the United States, there would have to be a demonstration that those were added value to the product. And so things that I might look at is how old are those patents, whether you made washing machines before, whether there were adequate substitutes for the infringing product in the market such that you would be able to make washing machines without the infringing product. That sort of information was not on the record. And so the only information that was in the record that was clear was, quote, not only the patent at issue, but the registered design right is the driver of customer demand. And so the design element was in the hypothetical known to be a driver of customer demand, and so I felt that that could not be discounted. I'll also note that after the infringement ended in 2022, the market share that defendant had in the market plummeted, demonstrating to me that the sole driver of their market share was the infringing patent. And so I mentioned earlier today that one of the exceptions to apportionment is the entire market value rule. And but for the design element here, this may be a situation where the entire market value rule would apply. And so with that, again, I applied the 4% royalty rate to the base here and came up with a calculation of 1.764 billion in royalty. I added that to the lost profit calculation to come up with 2.734 billion in damages. As to the issue of enhanced damages, I do agree with the defendant that under U.S. law, enhanced damages would not be awarded here for a few reasons. First, in the United States, a defendant is entitled to represent itself and maintain that it does not infringe, and so that alone would not make something willful. Moreover, the defendant here did do research to see whether or not their patent infringed, and while they did seek the advice of counsel who was not a patent lawyer, it again was not demonstrative of them trying to willfully infringe the patent. Nothing else in the hypothetical spoke to the element of willfulness, and so I would not award enhancement damages here. And so my total award damages would be 2.734 billion won. Thank you.
예, thank you, Judge Bisun. 예, 들으신 것처럼 이제
As you have heard, from each country's standpoint, the two arbitrators elaborated on their words, and we have some differences in Korea, and if it were a real case, then we would have expert opinions also, but thank you for your opinions given the limited circumstances and limited information. And when it comes to the word, they are very reasonable and acceptable, and they also provide us much insight. Now, I will provide the opinion based on the Korean system and also deliver the arbitral award. So this is based on the Korean system, and through interpreting, you will be able to hear what is on the slide. So I will give, this is the overview from 2019 July 10th up to 2022 May 1st. The defendant is producing and selling the defendant product, and only the driving unit is under the patent. And so the plaintiff is arguing for 83.2 billion damages, which is triple the damages calculated due to the enhanced damages. And there are two preliminary arguments. According to paragraphs 4 to 5 of Article 128, so we would have to determine whether enhanced damages can be applied in this situation. So starting from our main argument based on paragraph 4 of the article, it looks at the marginal profit. So the total sales minus the variable cost, and the total sales is stipulated here, and we need to determine what is included in the variable cost, and then we have to times it by the apportionment rate. A is there for us to plainly see, so we have to determine on the variable cost. So we have to deduct fixed costs such as the labor cost and the rent, and all else falls under the scope of variable cost. Plaintiff thinks only materials cost is applicable because the smaller the variable cost is, the plaintiff stands a better chance. And Judge Klein said that other variable costs should also be deducted. If we look at apportionment rate, it is a critical concept, and there has been a lot of discussion in the morning. And there are 10 parts in the machine, and the defendant has 19 IP rights. There is the design element and about 8.5 billion won of advertisement cost, and the cheaper price by 500,000 won of the defendant's product. So we are claiming a apportionment rate of 20%, and this has has to be proved by the plaintiff, and the plaintiff argues 100%, defendant argues 1%, but we rule it as 20%. If we calculate, so with the total sales, we times it by marginal profit and times it by 20%, and we arrive at about 2.1 billion Korean won based on the main argument. And if we go to the first preliminary argument based on paragraph 2, as discussed in the morning, there is the lost profit, and there is the hybrid calculation. So if it goes beyond the production capability, if there were other circumstances that hamper the sales, then this would be incorporated in the calculation. So on the marginal profit, the lost sales would be multiplied, and we would also times that by the apportionment rate. When it comes to the marginal profit per unit, it is given in this case. But in practice, the plaintiff is reluctant to prove that, so it is difficult to actually use this in real life cases, but here it is given. And the apportionment rate was decided as 20%. And the lost sales, well, I asked the defendant the question with regards to this. If defendants didn't sell their products, then would the entire quantity be attributable to the plaintiff, or would that amount be limited by the market share of the plaintiff? On this question, other factors are also claimed on side from market share, but it is difficult to accept them as grounds for calculation. Therefore, the entire defendant's sales is seen as the lost sales for the plaintiff, and Judge Bisun said that it should be calculated from the point of the receiving of the notice, and Judge Klein said that it should be limited to the market share. And we arrive at around 8.3 billion. So this is before we times it by the apportionment rate, and we look at the factors such as the quantity that goes beyond the production capability of the plaintiff, or reasons why, other than infringement, that could have hampered the sales, and we times it by the reasonable royalty rate. And when it comes to the reasonable royalty rate, two arbitrators arrived at 3% and 4%, and plaintiff argues 5%, defendant argues 0.5%. Well, given the new structure of the driving unit in the patent, and the royalty rate range between 1% and 5%, we arrived at the conclusion of around 2%. So we arrived at 1.18 billion won, and if we add the previous numbers onto this, then we arrive at 1.896 billion won. But now the outstanding issue is, as we decide the reasonable royalty rate, apportionment should be taken into consideration according to some. This is a critical issue, and right now discussion hasn't reached to that extent, but it is further complicated when we go to paragraph 5. Now, we are at paragraph 5. So on the total sales of the infringing product, we multiply it by the reasonable royalty rate, and the apportionment is not taken into account here. So it is the reasonable royalty rate here. It's the same as the paragraph 2, but why do we have apportionment incorporated in paragraph 2 and not here under paragraph 5? So some people say that apportionment should be multiplied to both numbers, but others say that apportionment is already taken into consideration in calculating royalty rate. I believe further discussion is needed here because paragraph 2 is considering situations that have hampered sales other than infringement. And paragraph 5, you are taking the total sales and then of the infringing product and multiplying it by the reasonable royalty rate. So I'm not sure whether the two are looking at the same thing. So hypothetically, we've calculated in both cases, and we can discuss it later. And since right now this is an arbitration, so we can employ quite a bit of flexibility here.
And about enhanced damages, so whether we can apply enhanced damages, a judge claims that there's no enhanced damages in Germany, but when determining the royalty rate, then other enhanced factors are considered. And in the US, enhanced damages is applicable, but not necessarily in this case. So we also looked at this case, and these are the reasons. For example, the defendant's size and position in the market, and the fact that they received a warning letter, but also even though they received a legal opinion, but was not from a patent lawyer. So these are hypothetical situations, but still, in an actual trial, we will have a much more detailed situation. So actually, when there is a legal opinion without specific analysis about the patent technology, then we have to be quite strict about that, I believe. So if you are going to get legal opinion, it needs to be really specific and concrete. So I want to send out that message to companies out there. And also, even after the defendant filed a lawsuit, they even increased the sales volume of this product. So that's another positive contributor for enhanced damages. Negative contributors, a few mentioned by Judge Bisun, and also they also have their own kind of a non-infringing technology, and they about 1.2 times for the enhanced amount seems to be appropriate according to the Korean law. I think in the US as well, it's the bigger amount is about 1.5 times. 3 times is rare but allowable. 5 times, I'm not sure if 5 times is allowable in China, but I guess 1.2 times in this case is appropriate. And so to calculate that, according to the primary case, 2.56 billion around about, and also so this primary amount is the largest amount compared to the secondary number 1 and second number 2 amount. So we will take that. And also, we also need to look at the delay damages as well. So about 6% per annum. And so we look at the time period between the receipt of the warning letter. And so overall, the amount is at the end about 2.863 billion. And Judge Bisun talked about 2.7 billion. Judge Klein 2.9 billion approximately. So luckily, I also arrived at a similar amount. So we are going to take an average amount of these three sums. So the average amount is 2.863 billion in Korean won. So now the plaintiff can ask the 2.863 billion to the defendant with a 6% an annual rate. And also, for the arbitration cost, 1/9 of the arbitration cost to the defendant and the other for the plaintiff. So this is the conclusion, and there is no material change happening right now. So this will be the conclusion of this case. If this is an actual case, we would take a lot of questions, but we cannot do that right now. So I apologize, but I want to thank all the attorneys here, and also particularly Judge Bisun and Judge Klein for their wonderful and insightful opinions. And also, I would like to thank both sides' attorneys for their hard work. And so, from Korea's patent court, going forward, we want to work with the people who actually practice patent law. So we will look at many theories and how these theories are practiced on field in many countries. We hope to bridge many countries in this regard. And so with that vision, with this, we'd like to conclude the arbitration proceedings here. Thank you.
클라인 판사님, 대단히 감사합니다.
Thank you, Presiding Judge Lee.
Thank you for this great session. I ask for your kindness understanding if you are not able to make more comments due to time constraints. All sessions were truly exciting and insightful. 대단히 감사합니다. 지금까지 매우 흥미롭고 유익한 시간이었습니다. 안타깝게도 이제 컨퍼런스를 마무리해야 할 시간이 되었습니다. 일단 모의중재에 참석하신 분께서는 앞으로 나와서 함께 사진 촬영을 해주시겠습니다. 사진 촬영 이후에는 폐회식을 진행하겠습니다.